But the problem is that there are minimum requirements that are set forth. You got to meet the minimum requirements. I mean, and what I hear you saying is that the delay is a cause for concern, and yes, it is. But that doesn't necessarily deal with this bill. It deals with the fact that the family law courts are the stepchildren of the court system. No judges really like doing family law, or if they do, they're sometimes a little, well, I won't say, no. But you've got to be a little crazy, I think, to like being a family law judge. And sometimes there are questions about the efficiency of the process. Sometimes there are questions about the work that's done. You know, nobody's perfect. But what we have here are parameters that the rules of court have set out for what we believe to be the necessary work done to do an evaluation, and recognizing that people are not perfect and that we make some mistakes. And we heard about some of the dramatic results of those mistakes. And I practice law and unfortunately did a great deal of this custody work, and it is a very flawed system, but it's the system we've got. If we can tighten it up, and I think this bill does that, and then if we can talk about harmless procedural and or technical errors, which I think at some point do deal with, address some of the concerns that you've articulated, but to say after 9 months that we're not going to follow or allow the court to consider something because they haven't followed the minimum requirements, it seems to me you get rid of that mediator. If they can't do the minimum standards that are required with the lives of children in their hands, don't we want somebody better who can do that? So I'm a little, I understood your opposition, and we worked hard with the senator to get to what I think is an appropriate balance. I'm just confused as to why this doesn't satisfy your concerns, and knowing that you all care about these, you know, if you do family law, you care about your clients and you care about these kids and what happens to them and how they get torn apart in these proceedings and how sometimes they get to the wrong parent. And that they're subjected to all sorts of issues that we heard articulated here. That's not the only instance of this, sadly, where the wrong parent had custody of the child, but we do the best we can. So why is this not a balancing that will allow the courts to do their job and hopefully to get the evaluators to do yours? That's a terrible question because it's open-ended, but I do want to hear an answer, and then I'll open it up to questions by other members.